Hello friends, in this video we will going to understand a very important concept of jurisprudence, which is the decline and revival of natural law theory. So in this particular video we will understand about a very important concept of jurisprudence, which is the decline and revival of natural law theory. So let us first understand what is the natural law theory. So let's first define the natural law theory. So the natural law theory is a philosophical perspective that points the existence of a set of universal moral principles inherent in nature, discoverable through reason. So natural law theory is some philosophical perspective which points the existence of certain universal moral principle. There are certain universal moral principle which is exist or inherent in nature, which is existing in nature and which can be discovered through reasons. So according to natural law school, there are certain laws which are immutable and eternal, and these laws are a constant body of permanent truth which is unaffected by human belief or attitude. So there are certain laws which exist in nature or which are immutable and eternal. Now the term immutable means that these laws are not changed with the change in time period or with the change in attitude of human beings or their belief. So it is eternal, it is not changed by anything, and it is exist in nature, and it is eternal, it is the made by God. So the natural law is something which is immutable and eternal, which is not changed by the attitude of human being or by their belief. So, and these laws are the constant body of permanent truth. Now that's why the natural law is also known as the moral law, because it mostly talk about the morality. It is also known as the divine law because there is a thinking that these laws are made by God. So it is also known as the law of God and law of reason. Now, the thinking of natural law is based on a priori proposition. Now, the term a priori proposition is the a priori knowledge. Those knowledge which is acquired independently of any other particular experience. So a priori knowledge is something which is exists in nature or all the human beings have, which is not acquired from particular experience. Now let's understand about the development of natural law theory. Now the development of natural law theory can be divided into four periods. So these periods are as following. So the first is the ancient period, then second is the medieval period, then Renaissance period, and then modern period. Now talking about ancient period, so there are certain propounders or thinkers of natural law theory in ancient period, which is Socrates, Plato, Aristotle, Zeno, and Cicero. Now talking about modern period, then the Thomas Aquinas is the most known person or known supporter of natural law theory. Now in Renaissance period, Hobbes, John Locke, and Rousseau are the most known person in the support of natural law theory. And in modern period, Steamer and other person are the most known and most contributed of the natural law theory. Now let's understand about the ancient period, which is the period of 2000 to 2500 year ago. Now in this period, in Greek, where there is a foundation or there is establishment of natural law theory, or we can say the establishment of philosophy in Greek. And in this philosophy of natural theory, three main figure is very well known, which is the Socrates, Plato, and Aristotle. Now, the interesting thing is that the Socrates is the teacher of Plato and Plato is the teacher of Aristotle. And as we know that the Aristotle is the teacher of Alexander. But we not talking about Alexander because he was not a philosopher. So the Socrates gives the theory or the concept of virtue. According to him, the every person have the virtue, which means the concept of good. According to the Socrates, he think that every person have the concept of good. Every person is able to understand what is good or bad, which is inherent in the human being. Now, the Socrates gives this theory, and he also gives a concept or method of research, which is called method of Socrates method, which is known as the Socrates method. According to him, in order to understand about a thing, first we have to make a hypothesis. Just like in research, first we make a hypothesis and then research. So he said that in order to understand something, we have to first make a hypothesis and then we have to cross check our hypothesis. Then we will understand about the right thing. So this concept is also known as the concept or method of Socrates. Now, Socrates is itself not written anything or its concept or idea, because he was penalized in that era, because the people think that he was corrupting the public, or youth. So he was penalized and poisoned and he was died. Now his student Plato published his idea and theories. Now Plato also give their own concept, which is the concept or doctrine of forms. According to Plato, in world everything is exist in a form, like virtue, goodness, God, everything is exist in form, only which we have to find it. Now the Aristotle, which is the student of Plato, also give their own theory and support the theory of natural laws. Now, only in Greek the supporter of natural law are not existing. After the Greek, in Rome there are also the supporter of natural law theory. In Rome there are two very known name exist, which is the name of Zeno and Cicero. Now this Zeno, talking about particularly Zeno, then he was a very rich person, and when he was get corrupted, then he read the theories and idea of Socrates and he was get inspired, and then he also worked in the field of natural law theory, and he also give the concept of stoicism and make the continuous conversation about the natural laws and teach their students, which he call Stoics. Now he was very inspired with the ideology of Socrates, and then he also in Rome imposed the natural law theory, and because of that there in Rome the three principles were existed or emerged, which is the concept of just civil, just natural and just gentium. Now talking about just civil, then just civil is the laws which is made for their civilians or their own public. Now the just natural are the laws which is related to the law of nature, law of God. And now talking about just gentium, which is the law made for the foreigners. And the interesting thing is that this is the first international law which is made by Zeno in Rome. Now talking about Cicero, Now, Cicerio is also a very known person in the field of natural law, and he was a lawyer. So he also support the concept of natural law and morality in laws. Now, talking about modern period, which is the period of 10th to 12th century. In this period, the concept of natural law was mainly supported by the Catholic theologists or the Christians, and this concept was flourished in the period of medieval Christian era. Now, in this field, a very well known name is come up, which is the name of Thomas Aquinas, and he gave their major contribution in the field of natural law, because on that era the faith of the people over the laws of church is declined day to day, so that the Thomas Aquinas tried to make the relationship or synthesize the theories of natural law or reason with the laws of church or the divine law. Now, talking about Renaissance period, which is the period of 14th century to 17th century. In this period, there are the multiple propounders who give their concept, and in this period a very important concept or principle come into existence, which is the social contract theory, which is given by various propounders of Renaissance period like Thomas Hobbes, John Locke, or Rousseau also. So all these propounders give their own concept of social contract theory, but in basic we have understand that on that era, due to the various war, the people understand that we can't survive if we fight continuously, so that they make a social contract. For example, we will not going to kill you or you will not kill us. So there are some basic principles or basic contract which they make under the social contract theory. Now let's understand the concept of revival of natural law theory. So during the end of 19th century and the beginning of 20th century, we saw the revival of natural law theory mainly due to the following reasons. So the first reason is it emerged as reaction against the analytical positivism. So the question arises is that why there is a reaction against the analytical positivism, and what is the meaning of analytical positivism? So in order to control a society or a country, there are two important things exist, which is the law and morality. But the concept of analytical positivism break down this principle and said that there is no rule of morality, only law will rule. Now this will create a huge hazardous or mass destruction of human beings. So that's why there is a reaction against the analytical positivism. So in order to understand this concept, I will take example of three countries, which is the Germany, Italy and Japan. Now in the 19th century, in these three countries, there is a dictatorship. Now talking about Germany, as we know that there is a dictatorship of Hitler. In Italy, there is a dictatorship of Mussolini, and talking about Japan, so there is also a kingship or kind of dictatorship. So in this country we see the same thing, that there is a dictatorship. And the analytical positivism, in analytical positivism we know a very important name of John Austin, who gave the definition that law is a command of sovereign which is backed by sentence. So according to him, law is the command of sovereign which we have to follow. And in this country the same thing is happen. The sovereign give the command and which the people have to follow, and due to which there is a very big war, which is the second world war, come into existence. And these three countries are the main reason behind the world war second. And in these all three countries we see the same thing: command of sovereign is the everything. There is a no role of morality, so that the people show their reaction against the analytical positivism. Now talking about the second thing, then it was realized that the abstract thinking was not completely futile. Now talking about the natural law, this is natural law, then it is the abstract thinking, because the natural law is something which is not concrete thing, or which is not a tangible thing, or which you cannot see. This is something which we can understand, and which is the sound of our soul. So the people understand after that the abstract thinking is not futile. It have the very important role in our society. So there is a rule, a very important role of morality in our society. Then the people understand these things. Now the third point is the idea of fascism. Now the idea of fascism includes the religion-based nationalism, militarism, and racism, or many more things. And the idea or ideology of fascism is the ideology of Mussolini, and due to which also laid down the revival of natural law theory, as at that time during the two world war the world witnessed a great destruction of human lives and property, and principle of natural law were approached in order to attain the peace. So that the people understand that if we fight, or if there is a rule of sovereign which is the ultimate thing, and there is a no rule of morality, then we will destroy the whole world, and there is a no existence of anything. So in the concept of revival of natural law theory, there are few concepts which is very important to understand. So the first concept is the concept of just law. Now the concept of just law is given by Stemmer, who is the propounder of natural law theory in modern period. Now according to him, the purpose of law is not to protect the will of one person, but to unify the purpose of all individual in the society. This shall bring harmony between individual and the community by making just law based on the principle of morality. So in simple word, we understand that the just law give more preference to collective interest. Now the another concept is the philosophy of heart. Now the heart concept give the philosophy of core and penumeral. Now according to him, just like the earth have a core or a penumeral, which is core which is something hard or rigid, or penumeral which is something soft. So law is something like that. There must be some certain law or rigid law or core law, but there are also some penumeral laws or laws which can be twisted for the welfare of the public. For instance, if you see in India, there are the system of courts or the hierarchy of court, but if there are some deprived class of people or backward class of people, and if their fundamental right is infringed, then they direct go to the Supreme Court and file a PIL. So this is something which is made for the deprived class or the weaker class of people to entertain their rights. So, law must be have some core laws or some penumeral which can be twisted for the welfare of the society. Now, let's understand the decline of natural law theory. Now, in the 19th century, we witness a significant decline in the natural law theory. Now, the decline was influenced by profound economic political transgression in Europe. Now, the major reason behind the decline and the supporter of this decline is the Austin and Bentham. Now, the Austin and Bentham was the influential figure in the decline of natural law theory during 19th century. Now, critique of natural law theory. So, the Jeremy Bentham criticized the natural law theory and advocated the utilitarianism and emphasized the importance of maximizing the happiness and minimizing the pain in law and governance. Now, according to Jeremy Bentham, the laws must be maximize the happiness and minimize the pain, so the utility of the people will ultimately increase. Now, the John Austin argue for the positive approach or positivism in law and emphasizing the importance of sovereign command. As we know that the John Austin give the definition of law, that the law is this command of sovereign backed by sanction, which means that the law is something which is commanded by sovereign, the ultimate authority, and if you cannot follow these law, then you must have to face punishment or sentence. Now, both Bentham and Austin criticized the natural law for its reliance on abstract or unchangeable principle. They view natural law as inadequate for addressing the complexity of modern society and performed legal system ground in positive or utilitarianism. Now, in this period, the social contract theory was also rejected, and many historians diminish the social contract theory as a myth and they reject the social contract theory. So, my conclusion is that with understanding the concept of decline and revival of natural law theory, we have to understand one thing is that we don't have to interfere with the laws of nature and natural laws. If we interfere with the nature, then we also have to face certain consequences or trouble, or if we try to infringe or violate the natural law theory, then we also face some consequences, as we seen in the period of 19th century as a two big world war. So this is something which I understand